The Supreme Court chamber fell silent as Representative Jasmine Crockett approached the podium, her bold red suit standing out against the dark wood paneling. The tension in the room was electric. Just moments earlier, Justice Clarence Thomas had leaned into his microphone with a dismissive smirk and said, "Congresswoman, perhaps you should review basic constitutional law before presenting arguments to this court." His unexpected jab at the freshman representative from Texas sent shockwaves through the chamber. Gasps and whispers erupted from the gallery. Cameras flashed frantically, and legal observers exchanged glances of disbelief. Crockett, a Harvard-educated attorney and rising Democratic star, stood frozen for a split second, the justice's words hanging in the air. Thomas, with his 30-plus years on the nation's highest court, looked confident that he'd put the young congresswoman in her place. But what happened in the next 5 minutes would leave Thomas speechless. The other justices, wide-eyed and conservative legal experts, scrambling to explain away what they had just witnessed. Before diving into this shocking confrontation, don't forget to like this video and subscribe to our channel for more compelling political stories that the mainstream media won't show you. Justice Clarence Thomas sat with the familiar stern expression that had defined his 3 decades on the bench. At 76, he remained the conservative anchor of the Supreme Court, rarely speaking during oral arguments, but wielding enormous influence through his written opinions. Today was different. The court was hearing arguments on a controversial voting rights case that had divided the nation along partisan lines. Democrats claimed new state laws represented voter suppression, while Republicans defended them as necessary security measures. Representative Jasmine Crockett had been invited to present arguments as an amicus curiae friend of the court due to her unique position as both a congresswoman and a civil rights attorney with extensive experience in voting rights cases. At 43, she had risen quickly through the political ranks, known for her sharp legal mind and fearless confrontational style in congressional hearings. Her district in Texas was directly affected by the laws under review, and she had personally represented clients challenging similar provisions before her election to Congress. The stakes couldn't be higher. This case would potentially impact millions of voters in upcoming elections, with implications for congressional races and possibly even the next presidential contest. Legal analysts predicted a 63 split along ideological lines, with Thomas expected to write the majority opinion, upholding the restrictive voting measures. Behind the scenes, Crockett had prepared meticulously for this moment, knowing she would face tough questioning from the conservative justices. Her team had compiled a comprehensive brief supported by statistical evidence, historical precedent, and personal testimonies from affected voters. What she hadn't prepared for was a personal attack on her legal credentials. Thomas had rarely shown such open hostility to advocates appearing before the court. His uncharacteristic remarks suggested something had touched a nerve. Perhaps it was Crockett's earlier comment during a news interview where she had referenced Thomas's controversial positions on voting rights cases, or her suggestion that the court had become too politicized. Whatever the reason, the justice had broken protocol, and now all eyes were on Crockett's response. As the congresswoman organized her notes at the podium, her mind raced. She could play it safe, politely acknowledge the justice, and move on with her planned arguments. Or she could stand her ground against one of the most powerful jurists in America. The next few minutes would define not just her reputation, but potentially influence the court's approach to this critical case. "Thank you, Justice Thomas, for your concern about my legal knowledge," Crockett began, her voice steady despite the tension. "I'd be happy to compare our understanding of constitutional principles, particularly as they apply to voting rights." Thomas leaned back slightly, surprised by her direct response. The other justices shifted uncomfortably in their seats. Chief Justice Roberts appeared ready to intervene, but hesitated. "Congresswoman, this isn't a congressional hearing where grandstanding is rewarded," Thomas countered, doubling down. "The question before this court is whether these state laws violate federal voting protections, not your personal political agenda." The gallery murmured as Crockett stood her ground, adjusting her stance at the podium. "With all due respect, Justice Thomas, I've litigated 17 voting rights cases, winning 15 of them. My arguments today are grounded in legal precedent, including opinions from this very court." Thomas's expression hardened. "Yet you seem to misunderstand the fundamental balance between state authority and federal oversight. Perhaps that explains your courtroom losses." A sharp intake of breath could be heard throughout the chamber. Justice Sotomayor glanced at Thomas with visible disapproval. Justice Kagan straightened in her chair, suddenly more attentive. "Justice Thomas," Crockett responded, her voice gaining strength. "I'm well versed in that balance. What troubles me is the selective application of state sovereignty when it disproportionately impacts certain communities." Thomas leaned forward. "It's der Staatsdesi, arot chisi." The Constitution doesn't guarantee convenience in voting, Congresswoman. It protects against discrimination, not inconvenience. Your confusion between these concepts is precisely what concerns me about your arguments. The tension in the room escalated as Crockett opened a folder on the podium. "I'm not confused, Justice Thomas. Perhaps I can refresh the court's memory on its own precedents." He pulled out a document as Thomas spoke again. "Congresswoman, need I remind you that I've sat on this court since before you entered law school?" "I don't need a refresher on our precedents." "With respect, Your Honor," Crockett replied, "I believe we all benefit from examining how consistently those precedents are applied." She turned to her notes in Crawford versus Marion County. This court acknowledged that voter identification requirements must be reasonably related to legitimate state interests and cannot place undue burdens on voters. Yet, the laws before us today go far beyond what Crawford permitted. Justice Allo interjected. Congresswoman Crawford established that preventing voter fraud is a legitimate state interest. These laws simply extend that principle. Crockett nodded respectfully to Alto, but kept her focus on Thomas. "Justice Alto, I agree that preventing fraud is legitimate. However, Crawford also required evidence that the remedy is proportional to the threat. When I asked the state's attorneys for evidence of widespread fraud that would justify these measures, they couldn't provide it." Thomas tapped his fingers on the bench impatiently. "The states don't need to prove fraud is rampant to take preventative measures, Congresswoman. That's a fundamental misreading of our jurisprudence." The confrontation was building toward a critical moment. Crockett had been challenged repeatedly, but had held her ground. Now she reached into her briefcase and removed a thick binder. "Justice Thomas, since you've questioned my legal understanding, I've prepared something that might interest the court." She opened the binder to a marked page. "This is a compilation of statements from your own opinions on voting rights cases over the past 15 years. Thomas's expression didn't change, but his posture stiffened slightly. The other justices leaned forward, curious about where this was heading. "In Shelby County versus Holder," Crockett continued, "you joined the majority opinion striking down Section 4 of the Voting Rights Act, arguing that the formula was based on outdated data and conditions had improved. You wrote separately that the coverage formula's desperate treatment of states was no longer justified." Thomas nodded slightly, standing by his position. Yet, just 3 years later, Crockett pressed on when presented with statistical evidence showing that, after Shelby County, voting restrictions increased dramatically in previously covered jurisdictions, affecting minority voters at 5 times the rate of white voters. You dismissed these statistics as manipulated data and political theater. She flipped to another page. In Bruno v. DNC, you went further, suggesting that Section 2 of the Voting Rights Act might not even authorize challenges to voting laws that result in disparate impacts on minority communities, a position even your conservative colleagues didn't fully embrace. Thomas's expression darkened. "Congresswoman, you're selectively quoting my opinions without context." "This isn't proper argument before this court." "I have the full context right here, Justice Thomas," Crockett replied, tapping the binder. "I'd be happy to submit it to the court." "What troubles me is not that you have a different interpretation of voting rights laws than I do. That's to be expected. What concerns me is the inconsistency in applying principles of statutory interpretation and constitutional analysis depending on the case." Before you. The chamber was completely silent. Now, even the court reporters seemed to be holding their breath. Chief Justice Roberts cleared his throat, preparing to redirect the argument. But Thomas spoke first. "Congresswoman Crockett, you're here to present legal arguments about the case at hand, not to critique this court's prior decisions or my jurors' prudence. If you have nothing substantive to add beyond political attacks, perhaps we should move on to the next amicus." It was a clear attempt to dismiss her, but Crockett wasn't finished. She reached for another document on the podium. "Justice Thomas, I have one more item that directly relates to the case before us today. It's from the congressional record dated June 1982. Thomas frowned, visibly confused about the relevance of a 40-year-old congressional document. "This is the testimony you gave before the Senate Judiciary Committee while serving as chairman of the Equal Employment Opportunity Commission," Crockett explained. "You were asked about voting rights and said, and I quote, The right to vote is fundamental to our constitutional democracy, and any measures that might impede that right deserve the strictest scrutiny, regardless of their stated purpose. The courtroom erupted in whispers. Thomas's face remained impassive, but his eyes narrowed slightly. "You went on to say," Crockett continued, her voice rising above the murmurs, "when state actions disproportionately affect minority communities' ability to vote, we must question whether the true motivation is electoral security or electoral advantage." Thomas's jaw tightened. The confrontation had reached a critical point. The justice who had mocked Crockett's legal skills was now facing his own words from decades earlier, words that directly contradicted his current jurisprudence. The moment hung in the air as Justice Thomas stared at Representative Crockett, the gallery completely silent in anticipation. Thomas leaned toward his microphone, his expression unreadable. "Congresswoman, those statements were made in a different context during congressional testimony, not judicial proceedings. My understanding of constitutional principles has evolved with experience and deeper study over 4 decades." Crockett nodded respectfully. "Evolution of legal thought is natural, Justice Thomas. I respect that. What I'm highlighting isn't the change itself, but rather the absence of acknowledgement that your views have reversed so dramatically." She paused, then continued with measured confidence. "The legal principle of stare decisis, standing by what has been decided, is fundamental to our system. When the court reverses long-standing precedent, it traditionally provides substantial justification for the reversal. Yet, in your opinions on voting rights, you've presented your current interpretation as if it were always your position, without addressing your earlier contradictory statements." Justice Kagan exchanged a glance with Justice Sotomayor. Justice Barrett shifted uncomfortably in her seat. "Furthermore," Crockett pressed on, "the congressional record shows that during your confirmation hearings, you assured senators that you recognized the historical struggles of minority voters and the importance of vigilant protection of voting rights. Many senators voted to confirm you based partly on those assurances." Thomas' patience visibly wore thin. "Congresswoman, this court isn't bound by statements made during confirmation hearings. Our duty is to interpret the Constitution as written, not as politicians wish it to be interpreted." Crockett was ready for this response. "I agree completely, Justice Thomas. Our duty is to the Constitution as written. And what does the Constitution say? The 15th Amendment explicitly prohibits denying the right to vote based on race. The 14th Amendment guarantees equal protection under the law. These aren't political interpretations. They're explicit constitutional commands." She turned to address the full court. "The evidence before you shows that these new state laws will prevent an estimated 1.4 million eligible voters from casting ballots. The state's own data indicates that Black and Latino voters are 3 times more likely to lack the newly required forms of ID. There are counties where the nearest office to obtain these IDs is over 100 miles away, open only during limited weekday hours." Crockett turned back to Thomas. "Justice Thomas, you wrote in Holder v. Hall that statistical evidence of disparate impact wasn't sufficient to prove discriminatory intent. Yet, in your 1982 testimony, you stated that persistent statistical disparities in voting access that fall along racial lines should create a presumption of improper purpose that the state must overcome." Thomas remained silent, his expression stone-faced, but his eyes intent. "I'm not questioning your integrity, Justice Thomas," Crockett said, her tone softening slightly. "I'm asking for consistency in legal reasoning. The same analytical framework should apply regardless of which party enacted the law or which communities are affected." Then came the moment that would be replayed on news networks for days. Crockett pulled out a final document from her folder. "I have here an amicus brief you helped author as an attorney for the Equal Employment Opportunity Commission in 1981. Before your testimony, I just quoted fascinating in it. You argued that seemingly neutral practices that result in disparate impacts on protected groups should be subject to heightened scrutiny, even without proof of discriminatory intent. To look directly at Thomas, you wrote, and I quote, 'When facially neutral policies disproportionately burden rights fundamental to full citizenship, particularly voting rights, courts must look beyond the stated rationale and examine whether the effect itself violates constitutional guarantees.'" The gallery erupted in murmurs. Justice Thomas's eyes widened slightly. This was clearly a document he hadn't expected anyone to unearth. It was from his early career before his juror's credential shift to the right, and it directly contradicted the legal philosophy he had championed for decades on the court. Thomas cleared his throat. Congresswoman, a brief written by government attorneys 40 years ago hardly. The brief is signed by Clarence Thomas, Assistant Secretary. Crockett interrupted gently, holding up the document so he could see the signature page. It represents your legal reasoning at the time, and it aligns perfectly with Supreme Court precedent from that era. Precedent that has since been eroded by decisions you've supported. She placed the document down and looked at each justice in turn. My legal argument today isn't radical or political. I'm simply asking this court to apply the same principles it once embraced. Principles that Justice Thomas himself once advocated. The right to vote is not a partisan issue. It's the foundation of our democracy. The chamber was completely silent. Chief Justice Roberts, sensing a pivotal moment, spoke up. Does the government wish to respond to the Congresswoman's arguments? The Solicitor General rose. Your Honor, the government stands by its brief. We believe Representative Crockett has raised valid concerns about the desperate impact of these laws that deserve the court's careful consideration. Thomas finally spoke again, his tone noticeably less confrontational. Congresswoman Crockett, while I maintain that my judicial philosophy is consistent with constitutional principles, I acknowledge that you have thoroughly researched my prior statements. That level of preparation deserves respect. It wasn't a concession on the legal merits, but coming from Justice Thomas, known for rarely acknowledging advocates' points during oral arguments, it was extraordinary. The subtle shift in his demeanor was evident to everyone in the chamber. Crockett nodded respectfully. Thank you, Justice Thomas. That's all any advocate can ask for, that their arguments be considered on their merits. As Crockett gathered her materials to return to her seat, Justice Sotomayor spoke up. Congresswoman, before you conclude, I have a question about the statistical evidence you've presented. Is it what followed was a 15-minute exchange with various justices, including several follow-up questions from Justice Thomas himself, who engaged with Crockett's arguments with unexpected seriousness. The justice, who had begun by mocking her legal skills, was now treating her as a formidable legal mind, worthy of rigorous debate. When the arguments concluded, legal analysts in the gallery were already typing furiously on their phones, knowing they had just witnessed an historic confrontation. Crockett had not only stood her ground against one of the court's most formidable justices, she had forced him to engage with her arguments on their merits after he had attempted to dismiss her. As she walked out of the Supreme Court building, reporters swarmed around her. Representative Crockett, how do you respond to Justice Thomas's initial dismissal of your legal skills? Crockett paused, then smiled slightly. I don't take it personally. In the courtroom, what matters isn't personal respect, but respect for the law and the facts. Today, I believe the facts spoke for themselves. Within hours of the Supreme Court hearing, video clips of the exchange between Representative Crockett and Justice Thomas went viral across social media platforms. Crockett, Thomas, and Legal Showdown became the top trending topics on Twitter, with millions of views on TikTok and YouTube. CNN's legal analyst, Jeffrey Toobin, called it one of the most remarkable confrontations in Supreme Court history. Fox News contributors debated whether Thomas had underestimated Crockett or whether she had crossed the line by confronting a Supreme Court justice so directly. Conservative legal commentator Jonathan Turley wrote, "While I may disagree with Representative Crockett's conclusions, her preparation was impeccable. She came armed not with rhetoric, but with Justice Thomas's own words. That's effective advocacy, regardless of one's political leanings." Liberal commentator Rachel Maddow dedicated her opening segment to the exchange. What we witnessed today wasn't just political theater. It was a masterclass in how to challenge power with preparation and precision. Crockett didn't try to outshout Thomas, she out-researched him. The White House press secretary was asked about the confrontation during the daily briefing. The president believes in the independence of the judiciary and won't comment on specific exchanges during oral arguments. That said, he has always maintained that voting rights are fundamental to our democracy and should be protected vigorously. Republican congressional leadership was more critical. The House Minority Leader issued a statement. Representative Crockett's confrontational approach to a Supreme Court justice shows the Democrats' disrespect for our institutions. Justice Thomas deserves better than to have his decades of jurisprudence mischaracterized for political gain. Democratic leaders rallied behind Crockett. The Senate Majority Leader tweeted, "Proud of Atrep Crockett for standing up for voting rights with brilliance and courage. This is why representation matters in Congress." Civil rights organizations celebrated Crockett's performance. The NAACP Legal Defense Fund issued a statement. Representative Crockett articulated precisely what we've been arguing for years. that the court's retreat from voting rights protections contradicts not only precedent, but the Constitution itself. Behind closed doors, the impact on the justices themselves was significant. Sources close to the court reported that during their private conference to discuss the case, Thomas acknowledged Crockett's points about his earlier writings, though he maintained that his judicial philosophy had evolved appropriately over time. According to these sources, Justice Barrett asked whether the court should address the statistical evidence of disparate impact more directly in their opinion, regardless of how they ultimately ruled. Chief Justice Roberts, always concerned with the court's institutional legitimacy, suggested that the majority opinion should at least engage substantively with the historical arguments Crockett had raised. 3 weeks later, when the court released its decision, legal observers were surprised. While the court still ruled 54 to uphold most of the contested voting provisions, the majority opinion, written by Chief Justice Roberts rather than Justice Thomas, as expected, included significant qualifications. The opinion acknowledged that states must provide reasonable accommodations for voters who face substantial burdens in obtaining the required identification. It mandated that if the nearest ID issuing office was more than 25 km away, the state must either open additional offices or provide free transportation services. The court also struck down provisions that eliminated Sunday voting, a direct response to Crockett's evidence about the desperate impact on black churches' souls to the polls' initiatives. Most surprisingly, Justice Thomas filed a concurring opinion rather than joining the majority in full. In it, he wrote, "While I agree with much of the court's analysis, I write separately to emphasize that our voting rights jurisprudence must remain grounded in constitutional text and history. The 15th Amendment provides explicit protection against racial discrimination in voting, and courts must remain vigilant against subtle forms of such discrimination." Legal scholars immediately noted that this language echoed some of the points Crockett had raised during oral arguments, a remarkable shift in tone, if not in substance, from Thomas's previous opinions. For Crockett herself, the aftermath was transformative. Interview requests poured in from major networks. Law schools invited her to speak about advocacy before the Supreme Court. Her social media following tripled. Overnight, when asked on Meet the Press whether she had expected such a reaction to her Supreme Court appearance, Crockett smiled. "I didn't go there for attention. I went there to make the strongest case possible for protecting voting rights. That's always been my mission from my days as a civil rights attorney to now as a congresswoman." The host pressed further. "Were you intimidated when Justice Thomas dismissed your legal skills?" "Intimidated? No," Crockett replied thoughtfully. "Surprised? Yes, Supreme Court arguments are supposed to focus on the merits, not personal attacks. But I've faced tougher challenges in my career. When you're prepared, when you know the law and the facts support your position, you don't need to be intimidated by anyone, even a Supreme Court justice." 6 months later, the practical impact of the court's decision and Crockett's role in shaping it became clear. States with strict voting laws were forced to make significant modifications to comply with the court's new requirements. Voter registration drives reported increased participation in minority communities, partly inspired by the viral clips of Crockett standing up for voting rights. Political analysts began mentioning Crockett as a potential future candidate for Senate, or even higher office. "What makes Representative Crockett different," wrote one columnist, "is that she combines political skill with genuine legal expertise. She didn't just score political points against Justice Thomas. She changed his thinking, at least marginally. That's the kind of advocacy that makes a lasting difference." Perhaps the most telling aftermath came a year later when Crockett again appeared before the Supreme Court in another voting rights case. This time, Justice Thomas treated her with notable respect from the outset, engaging seriously with her arguments rather than attempting to dismiss them. After that argument, a reporter asked Crockett if she felt vindicated by Thomas's changed demeanor. She shook her head. "This isn't about me or Justice Thomas personally. It's about ensuring that every eligible American can exercise their right to vote without unnecessary obstacles." On that front, we still have work to do. The confrontation between Representative Jasmine Crockett and Justice Clarence Thomas became a case study taught in law schools about effective advocacy against established power. It demonstrated how thorough research and calm persistence could prevail over attempts to dismiss or intimidate. Most importantly, it showed that in a democracy, even the most powerful officials can be held accountable to their own words and principles. As one constitutional law professor put it to her students, Crockett didn't win by attacking Thomas personally. She won by making it impossible for him to dismiss her without dismissing his own earlier stated principles. That's how you change minds, by finding common ground and then showing the inconsistency in abandoning it. For millions of Americans, particularly those from marginalized communities, the confrontation represented something even more fundamental. Proof that speaking truth to power could actually make a difference. Crockett had entered the highest court in the land, faced dismissal from one of its most formidable justices, and not only held her ground, but changed the outcome of a case affecting millions of voters. The story of Jasmine Crockett and Clarence Thomas serves as a reminder that in American democracy, no position is too powerful to be questioned, and no voice too new to be heard. As long as that voice comes prepared with facts, history, and the courage to use them effectively. If you found this story inspiring, don't forget to like this video and subscribe to our channel. Hit the notification bell so you never miss our coverage of the political confrontations that are shaping America's future. Leave a comment below, telling us which political showdown you'd like us to cover.